Judge Scott McAfee dropped 6 charges in the Trump election interference case in Georgia. We've been talking about this case for a while. We've mostly been focused on Fani Willis's hearing on whether or not she will be replaced as serving district attorney and prosecuting for the state against Donald Trump and his co-defendants. We're still waiting the results of the hearing, and soon we'll know whether or not Fani Willis is on the case or it will be transferred out to a different county. But in a bombshell this morning, Judge Scott McAfee drops the charges, 6 of the charges. 6 out of what we're counting is 41 charges, I believe. 3 of those charges will actually impact Donald Trump personally. 3 will apply to some of his alleged co-conspirators, including Rudy Giuliani, John Charles Eastman, Mark Randall Meadows, Ray Stallings Smith, and Robert David Cheeley. And the funny thing is, this thing really reflects poorly on Fani Willis's DA's office, because the judge says there is enough information for you to indict on these charges, to charge these people in these counts, but it wasn't done properly, right? Yeah. And if it isn't done properly, he's saying these charges have to be thrown out. What counts are they? The defendants challenge counts 2, 5, 6, 23, 28, and 38 of the indictment by way of special demurrer. Demurrers provide a means for the criminally accused to ensure the state's charging document satisfies the constitutional mandates of due process and the Sixth Amendment. And what that means, according to the judge, is the test is whether the indictment could have been made more definite and certain, but whether it contains the elements of the offense intended to be charged and sufficiently apprises the defendant of what he must be prepared to meet. And in case any other proceedings are taken against him for a similar offense, whether the record shows with accuracy to what extent he may plead a former acquittal or conviction. It sounds like Judge McAfee is shoring up this ruling so that when he rules, there's not enough room for somebody to be tried in double jeopardy, being tried again twice, or for his ruling to not stand on appeal. Now, if you remember correctly, in the radio interview we heard that Scott McAfee, he's made a draft of his decision and he's been taking this time, and he has now a new challenger. He had already made this draft before that. So he's trying to be thorough. What he's trying to do is make sure that Trump and his co-defendants know exactly what they're being charged for, and it's clear and succinct and perfect. The ultimate purpose is to put the defendant on notice and the state has fallen short. The 6 counts are similarly structured and can be summarized as follows. Count 2 alleges that multiple defendants solicited elected members of the Georgia Senate to violate their oaths of office December 3rd, 2020 by requesting or importuning them to unlawfully appoint presidential electors. Count 5 alleges that defendant Donald Trump solicited the Speaker of the Georgia House of Representatives to violate his oath of office on December 7th, 2020 by requesting or importuning him to call a special session to unlawfully appoint presidential electors. Count 6 alleges that defendant Smith and Giuliani solicited members of the Georgia House of Representatives to violate their oaths of office on December 10th, 2020 by requesting or importuning them to unlawfully appoint presidential electors. Count 23 alleges that multiple defendants solicited elected members of the Georgia Senate to violate their oaths of office on December 30th, 2020 by requesting or importuning them to unlawfully appoint presidential electors. Count 28 alleges that defendants Trump and Meadows solicited the Georgia Secretary of State to violate his oath of office on January 2nd, 2021 by requesting or importuning him to unlawfully influence the certified election returns. Count 38 alleges that defendant Trump solicited the Georgia Secretary of State to violate his own oath of office. Count 38 alleges that Donald Trump solicited the Georgia Secretary of State to violate his oath of office on September 17, 2021, by requesting or importuning him to unlawfully decertify the election. So these are the specific counts that have been dropped from the case. The counts that still remain, 41 in It was 41 in total, so I think we're down to 35 now, 35 counts. One count of violating the Racketeer Influence Corrupt Organizations Act, one count of conspiracy to commit impersonating a public officer. All right, we've got the forgery of false statements and writings. I believe some of those are covered under the 6. One count of filing false documents, one count of conspiracy to commit filing false documents. Okay, those two are counted off as well. So we're still with racketeer influence. The RICO charge still stands. Trump is facing 13 of those felonies. In March 2024, Judge Scott McAfee threw out 6 of the charges, including 3 against Trump, because McAfee found that the allegations supporting the charges were not detailed enough. Right? But prosecutors can refile those charges with more details, and the most serious charge still stands: an alleged violation of the State Racketeer Influenced and Corrupt Organizations Act, commonly known as RICO. So this is the important part of their argument. Defendants first argue that the indictment is defective because the charging language does not cite the oath each of these solicited public officers was required to take. So basically, it's not specific language in what oath and specifically which part of their specific oath for these positions within the state of Georgia did they violate. Even if the relative oaths are apparent as a matter of law, the defendants further contend that the counts do not detail the exact term of the oaths that are alleged to have been violated. And then in sort of a reprimand to the district attorney's office in Fulton County, the judge writes, as written, these 6 counts contain all the essential elements of the crimes, but fail to allege sufficient detail regarding the nature of their commission, i.e. the underlying felony solicited, Kimbrough. They do not give the defendants enough information to prepare their defenses intelligently, as the defendants could have violated the constitutions and thus the statute in dozens, if not hundreds of distinct ways. Which means if I can't prepare for my case, then I might have violated in ways that I couldn't have imagined. I think this also goes into the idea, one of the weaknesses of this case is that what if Donald Trump was in the mindset that he was acting within his right because he was under the impression that he won? Which is what I've been saying from the beginning. You can listen back to some of my old videos. I said that. The one catch that he has, though, is this passage. However, those pleading deficiencies do not apply to the corresponding overt acts listed in count 1 specifically, which is the RICO charge, overt acts 23, 42, 55, 102, 112, and 156. Overt acts alleged as part of a conspiracy are not held to the same pleading standards as statutorily based offenses. Instead, all that is required is a reference to the overt act alleged by the state. So this is lining up the case in the trial as it goes forward. The remaining counts here, the overt acts, as he says. And even then, a defendant can be found guilty of conspiracy even after acquittal of any overt acts alleged to have been committed by that defendant, as long as at least one overt act is proven to have been committed by a co-conspirator. Defendants have not provided any authority requiring that the particulars of an overt act be alleged or subjecting overt acts to the standard of general or special demurrers. The defendant's challenge of these overt acts is therefore denied. So ordered, March 13th. So basically now this case is going to come down to the overt acts because of the writing of the charges that were there. Like he says, there is a possibility that the state can reintroduce those counts, but they'd have to be written so that they actually are specific. And as he says, perfect in form as well as substance. There we have it. Well, What do you all think about that? Are we starting to exploit some of the deficiencies in Fulton County DA's office? Let me know what you think about it in the comments. If you like this video, like, comment, subscribe. Hit the bell notification for all uploads. If you want to watch more, please watch one of these videos down below.